Well, good afternoon.
No.
So, I know I've heard, and we'll have to get them to cover this at some point, I know I've heard Florida is a judicial hellhole. I know I've heard that for many years, that we are a judicial hellhole. So I'm going to have one of them address that. I know there's been for years talk about a tort tax, something that we all pay relative to costs of litigation in the state. So I know we're going to have to talk that. I know we feel like we're always towards the bottom when it comes to a favorable legal system. And so that's part of what these guys are going to talk to us today about. There was a big session, 2023 just recently. A lot of reforms that I'm sure both of them are going to cover. I think William maybe a little bit more from a technical aspect, and then Ashley a little bit more about how that's impacting some insurance and businesses. So I'm just going to run through some brief introductions, and then we'll turn it over and let, I guess, one of them go for a little bit, let the other go for a little bit, and then, of course, as usual, we'll get into some questions and answers. William Large is the, I guess, president of the Florida Justice Reform Institute. He's a passionate advocate for legal reform, an experienced attorney who led Governor Jeb Bush's fight to reform medical malpractice rules that were to cap damage awards. As president of the Florida Justice Reform Institute, he's responsible for the daily operations of the research and lobbying organization that's based here in Tallahassee. Brings an extensive legal and political expertise to the advocacy group and has worked at some of the highest levels of government to bring about civil justice and tort reform. He was a deputy chief of staff to Governor Jeb Bush, responsible for coordinating and advancing a lot of the governor's vision to the state agencies. So he's worked with, too many to name, but the Agency for Persons with Disabilities, Agency for Healthcare Administration, Department of Veterans Affairs, Department of Business and Professional Regulation. So many of those I could go on, but I won't. And I gather from Facebook that William likes to do some outdoor activities, hiking, maybe camping. I just see he seems to always be smiling in pictures when he's in the outdoors, so I feel like that's where he likes to be. Ashley Kalifeh is a partner with Capital City Consulting, one of the largest lobbying, consulting, PR firms in the state. After several years of practicing as an attorney and working with the Florida Senate, Ashley moved over to the Department of Financial Services, where she served as a deputy CFO and legislative affairs director. So there she oversaw all the legislative policy matters for the CFO, as well as issues before the Florida Cabinet. Her experience spans really all insurance markets, property, auto, workers' comp, life, health, as well as agency regulations, state contracting, civil justice. It's a shame Will's not here today. Since joining Capital City in 2013, she's been involved in a number of high-profile reforms to Florida's insurance market and has been recognized for her work exposing problematic issues. She has a graduate degree, she is a graduate of Vanderbilt, but she has her law degree from Florida State University's College of Law. And she has more than a decade of experience in representing clients before legislative and executive branches, particularly on matters relating to financial services, tort reform, appropriations, environmental, and health care issues. So with that, I'm going to turn it over. I guess who's going first? Did y'all flip a coin? William wins. William's going first. William Large with the Florida Justice Reform Institute.
Hey everybody, I'm William Large, President of the Florida Justice Reform Institute. Thank you so much for having us here today. A little bit about the Institute. It's a 501c4 not-for-profit that advocates for tort reform in all three branches of government, the legislative, executive, and judicial branch of government through our amicus program. We hire lobbyists. My top lobbyist is Ashley Kalifeh, and we couldn't have gotten these reforms done this year without Ashley really behind the scenes. So we're going to go through some of the substantive issues and explain them to you. By far, this was the biggest, most expansive civil justice reform bill that passed in the state of Florida during my professional lifetime, and indeed that it passed around the country recently. So a lot of credit goes to Governor DeSantis, our House sponsor, Representative Tommy Gregory, and our Senate sponsor, Senator Hudson. But what are the substantive issues that were in here, and what does it mean? We're going to go through them sort of one by one. First is multiplier reform. believe it or not, there was a way for plaintiffs' attorneys to get their fee multiplied by a factor of like 1.5, 2.0, 2.5. So let's say that they had an hourly rate they claimed to be $675 an hour, and they had 100 hours in the case. That would generate a fee of about $67,500. Okay, they get that in through expert testimony. One of their brethren would say that that is the proper fee in the relevant geographic area. They would testify under oath that they had 100 hours. But then they would ask the judge to multiply that by a number, such as 2, okay, 2.5. What were the factors that led a judge to determine whether or not something should be multiplied? These were the nebulous factors that existed prior to House Bill H 37. So you can see there are things about the fee customarily charged in the locality, the nature and length of the professional relationship, the experience, reputation, and ability of the lawyer. All of those things are somewhat nebulous. It's very difficult for a circuit judge, those are your trial judges, to say, well, you don't really have the experience, you don't have the reputation, you don't have the background. So because of that, multipliers were frequently awarded and fees were doubled. So Governor DeSantis, Representative Gregory, and Senator Hudson said, you know, if you're going to have a multiplier, it should be used in rare and exceptional circumstances only. It shouldn't be for your run-of-the-mill case where it's very easy for someone to find a plaintiff's attorney today via Google, old school yellow pages, okay? People claim to have that expertise so they don't have to really relearn the law. Multipliers were really started in the 60s for civil rights litigation when it was a new area of law that no one really had studied or known, so that's why multipliers were being given. It was never meant for personal injury litigation, run-of-the-mill property litigation. It was the governor's viewpoint that this had come to the point where it was now being abused and multipliers were being handed out like candy. So this is the new standard. It makes sense, and this is what we have now in Florida. Ashley's going to take the next issue, one-way attorney's fees.
Thanks for having me, and William. I met William back when I was in law school, so this is kind of a full circle moment. It was a full circle session for us. I guess just to go back a little bit, tort reform means something different depending on where you are, right? I mean, people talk about tort reform and it's this big thing, but it's kind of what are your problems in the civil justice system? Where are they coming from? What's costing people money? What's kind of making it unaffordable to run your business? And so what happened with House Bill 837 is the legislature and the governor's office kind of looked at the top issues that were really affecting the economy in Florida and kind of put them all in one bill. And so I don't think anyone has seen their insurance rates go down lately. In fact, it's probably getting harder and harder for you to find insurance. And so a lot of the things that you saw in this bill were either well-intentioned laws that had been expanded by Florida courts to kind of mean something different than what they were intended or apply in a different way that they were intended, or just kind of an area of law where the legislature hadn't yet spoken and kind of mischief just started to operate. And so that's how we got there. We had a pretty plaintiffs-friendly Florida Supreme Court for a very long time, and they made a lot of very bad laws, or they interpreted laws poorly, and it resulted in kind of an explosion and gasoline on a litigation fire. And so the contingency fee multiplier is one example of that. Contingency fee multipliers actually historically were used in like civil rights cases back in the South when people didn't want to represent black people. And at their own personal expense, some lawyers would, and we all thought that was a worthy and good thing, that we would actually kind of enrich them for that because they were doing it at, sometimes at the expense of their own personal safety. And so contingency fee multipliers aren't necessarily a bad thing if they're used in truly rare and exceptional cases. But we had our former Florida Supreme Court, fortunately Governor DeSantis has reformed our Florida Supreme Court to be kind of have a lot more fidelity to the rule of law. But the former Florida Supreme Court said, yeah, I know what these were intended to do, but I'm going to apply them to like everything. And then it got applied to like run-of-the-mill lawsuits where there was really no lack of attorneys, no unwillingness for attorneys to take these cases, and it just resulted in costs, right, at no kind of societal benefit. So it was a good thing that became a bad thing through bad law. Another thing that was a good thing that became a bad thing through bad law is one-way attorney's fees. So when you think about, your kind of bargaining power against your insurance company, you kind of feel like you probably don't have the upper hand, right? And I think that's I think that's the truth, right? And so the legislature years ago, about 70 years ago, said, hey, we're going to allow you that if you have to litigate against your own insurance company, so it's a policy that you bought that inures to your own benefit, and you win, you get all of your attorney's fees paid for. Well, that sounds good, right? It sounds like, maybe bringing David up to Goliath's level. The problem is through a series of more recent court decisions, they actually applied that statute to situations that were not even contemplated. So what happened is they applied it to price disputes. And I don't know if anyone has ever had work done on their home in this room, but that's probably happened where you call 3 plumbers when you have a plumbing job. And it's not an exact science, it's not geometry, right? Someone says it's 22,000, someone says it's 2,200, and someone says it's 2,500. They're all right, none of them are wrong. If you were the insurance company and you picked the 2,300 guy, because the 2,100 guy seemed a little sketch, the 2,300 guy seemed right on the line, 2,500 guy, why was he charging 2,500? You would actually get sued because it said you should have paid 2,500 instead of 2,300, because it applied this statute to kind of run-of-the-mill price disputes. And again, this is not geometry, this is not an exact science, and it became a way for vendors to kind of get in there and inflate their bill and then threaten litigation against the insurance company if they didn't pay the inflated bill. So it was a good thing that actually ended up, because of interpretations, actually discouraging value, right? When you buy an insurance policy, they don't just say, yeah, pick whoever you want, and even if you had a Ford before, get a Cadillac, who cares? Like that's not what insurance is for. It's to kind of put you back in the right position. And so the one-way attorney fee applied to all first-party coverages, again, where you buy the policy and you're the policy holder. So property, PIP, which is the first kind of line of benefits that we buy in auto, and also auto glass, which is usually a coverage that we buy in our comprehensive and collision coverage. I know there's an Allstate agent here that can drill down in that more for you. But so what happened is vendors kind of came in, and I think we've seen them even in our community of Tallahassee. Roofers come in and say, free roof, just let me kind of get in there and take a look at your roof, and then I'll have you sign this cute little contract, and I'll get kind of all of your benefits, and that allows me to get that cool one-way attorney's fee statute. So when I send them a bill for a roof that probably could have been done for $50,000 or $60,000, but I send them a bill for $85,000, they're going to have to pay it, or I'm going to tie them up into litigation. And even if they win, the insurance company, they still have to pay all of their defense costs. So it was a Hobson's choice for an insurance company, and it became just pay all these really inflated bills or fight, which usually ended up costing more. And so William and I actually started doing research on this problem before I had my first child, and she just turned 6 last week. So we've had a lot of losses before we've had a win. But I'll give you a couple statistics, and we've published a number of papers that are all on William's website, but from January to March of 2021, there were 24,000 property insurance lawsuits in the state of Florida. 22 attorneys filed 200 each in just a 3-month period, and 2 attorneys filed 1,000 each. And I can give you 15 filed over 300, so in a 90-day period just of calendar days, that's how many lawsuits just one attorney was filing in the property insurance space. Over a 3-year period, one attorney filed 3,000 lawsuits. In 2021, in total 2021, there were about 40,000 lawsuits by 50 attorneys, and that meant they averaged about 784 lawsuits a year. And there are 365 calendar days in a year, so that's assuming, I guess, they didn't take any vacation. So that's the kind of scale that you were seeing. You were seeing the same thing in PIP, actually worse in PIP, and you were seeing the same thing in glass, and we'll talk a little bit about that. But what the legislature did is said, hey, apparently we can't have nice things. The one-way attorney fee statute was this cool and nice thing, but I don't think we can have that anymore because it's become an awful thing, and it's just continued to raise rates. And so fortunately, the legislature in the special sessions on property insurance that I'm sure you read about late last year. They repealed it for property insurance, and then they kind of completed that mission in House Bill 837. So hopefully some of the volume will stop. I think that based on when this is going to be fully implemented, you're going to kind of see another year or two of as bad as it's been. But then hopefully when insurance companies really start seeing their loss costs get reduced as a result of this law, it'll start to get baked into rates, and hopefully everyone will see some much needed relief.
Thank you, Ashley. For this issue, as well as some of the others, what I've tried to do is show a number of attorneys that were there in favor and the number of attorneys that were opposed. The attorneys opposed are the plaintiff's attorneys, just so you understand my firm belief that tort reform is the most difficult issue to lobby at the state capitol, because these are the people coming in opposed to what you're doing, and you need the people who are under the yes column to support the propositions that we're putting forward. So it makes it for a very difficult, contentious type of issue to get across the finish line. The next substantive issue that is in the bill is the statute of limitations. The statute of limitations in Florida for a negligence claim was 4 years. It's now been reduced to 2 years. What were we seeing? What were we hearing? Well, a lot of business owners, some of them from Tallahassee area and the Panhandle, particularly in the retail space and the restaurant space, would talk about the following phenomenon. Someone slipping and falling in their restaurant, getting up, saying that they were okay. Risk management protocols were in place. Walter, the waiter, Bobby, the bartender, were there, filled out their recollection of events. What happened? Was there any foreign substance on the floor that caused them to slip? And the owner thought, well, there's not going to be a lawsuit. 3 years, 363 days later, lawsuits filed, right on the end of the 4-year statute of limitations. It's very difficult as a business owner or a defendant to defend cases when your wait staff, your employees don't work there anymore. You can't contact them, okay? Wally the waiter, cell phone's been disconnected. You don't know where Bobby the bartender is anymore. So a lot of these lawsuits were strategically filed right at the tail end of a very long statute of limitations for a strategic reason, to make it more difficult to defend these cases. If the cases had merit, why wasn't the lawsuit filed much earlier? So now the statute of limitations for negligence claims in Florida is going to be 2 years. And that's a public policy decision that the governor and the legislator made, comparing what's happening in other states. Again, very contentious issue. Next is an issue called third-party bad faith. This one's a little bit more difficult to explain, so I'm going to show a diagram to you here. And these are the folks in favor of it. Big-time attorneys there, Dale Swope, Fred Cunningham, and others opposed to it. I could use any one of numerous diagrams here, but I'm trying to explain that at time 0, there was a car accident, okay? What was happening in Florida when 3 things were present: low insurance limits, someone driving around on a $25,000 policy, okay? Clear liability. I'm the tort reform guy, and I'm telling you it's a tort, okay? Okay? And catastrophic damages. Someone's dead. Someone's severely injured in the hospital. When those 3 things are present, and I call that the unholy trifecta, in Florida, no plaintiff's attorney had the incentive to settle the case, okay, easily. What they wanted to do is set up an insurance company for a distinct and separate case, okay, but kind of related, called a bad faith case, about how did the insurance company handle the case. The real beneficiary of this sort of type of lawsuit is the insured. Ostensibly, the insured is now facing an excess verdict because an insurance company didn't properly handle a claim. In Florida, there is an existing duty on the part of an insurance company to tender their limits in the absence of a demand in a clear liability case. So when one of these accidents happens, an insurance company has to tender the limits. That's the law, prior to an attorney getting involved, okay? So it makes you kind of question the whole, why is people getting 20%, 30% of this as a contingency fee. But what was not clear was the time. So insurance companies were tendering on day 14, day 21 after the accident, not after a complaint was filed in court, but after the accident. But that would never seem to be quick enough. As a result, plaintiff's attorneys would say, if you had only tendered on day 1, I gladly would have accepted it, but you took 21 days to tender, so I have no recourse other than to file a lawsuit, get a $10 million verdict, which is certainly possible with the fact patterns I've described, and then somebody owes on a $25,000 policy the gap, $9,975,000. It's either the insurer or the insured, okay? The insured, when then facing with this, then assigns his right to the claim to the third-party plaintiff, the injured person. And in exchange, he testifies, I paid my premiums month after month, year after year. I thought the insurance company was going to be there, but now they apparently dillied and dallied for 21 days when I'm being told by Mr. Plaintiff's attorney he gladly would have accepted the policy limits on day 1. So I'm facing this excess gap of $9,975,000. It's XYZ insurance company's fault. That second jury, when they're impaneled, is told there's been a horrific accident. A previous jury has determined that the value of the case is $10 million. You're here for only one thing. Is it John Q. insured who pays, who has no assets, okay? Or is it XYZ insurance company that does commercials on the Super Bowl, Sugar Bowl, 24/7? Every one of these cases, insurance companies was losing because there was a conflation between the accident, okay, and the claims handling procedure. In every other state, this would have been a $25,000 policy claim. In Florida, it was becoming a multi-million, $10 million claim. So in Florida, the law is now you have 90 days to tender from the accident, not from the complaint, from the accident, which just gives an insurance company an opportunity to speak to the insurer, review the accident report, assess what happened. And that's basic fundamental fairness, and that's what this law does and now addresses. Here are some other examples. There's a bunch of them. I could go through them, but this was a systemic problem. Offer of judgment, that is a way that you can get fees. It applies to insurance policies, and that's actually a pro-consumer part of this legislation. Transparency and damages. This one is also a very important issue for you to understand, and this is what, in my opinion, was the biggest cost driver in civil litigation. So I'm trying to explain this to you, and here are the people that were in support. This is the people who are opposed. These people don't show up opposed to this unless this is truly, really a big deal for them, okay? And you can see the amount of attorneys that testified on this subject. So the biggest component, the most important component, in my opinion, to damages in a tort case are the past medicals. And when I say past medicals, remember that car accident? I'll call that time 0. Up until the case is tried, and it might take 2 or 3 years to try, a plaintiff is seeing a doctor or doctors or chiropractors for their injuries. So from the time of the injury, time 0, to the time of the trial, they've accumulated past medicals. The bigger the past medicals tend to be, the bigger the overall value of the case tends to be. You can see that with respect to future medicals. If pasts are a big number, then something in the future from the time of the trial to the rest of the person's life should be bigger. And it has a tendency to pull everything else and make it bigger. The plaintiff's attorneys know this, so the way that they inflate intentionally, artificially, past medicals was through the use of something called a letter of protection, which was a promise to pay a doctor in the future when the verdict or settlement comes in, but not today. So an injured person would usually be told, hey, I know you have a great doctor. Hey, I know you have insurance. I don't want you to use your insurance. I don't want you to see your doctor. Instead, I want you to see my doctor. And good news for you, My doctor is going to treat you under something called a letter of protection, which is a promise to pay in the future, right now, not right now, so you don't have anything to pay right now. But these letters of protection tended to be fivefold, sixfold, sevenfold greater than the market price. We collected these examples. This is just one of them. This was a slip and fall case. The plaintiff was a Medicare patient, okay? Had she used her Medicare, it would have cost $7,721. Now, the way I got these numbers, this was a case that actually had been introduced into trial, and the evidence had come in. I hired a coding expert after the fact. I said, look at these medicals. What would this have cost had this lady used her Medicare? Well, she didn't. She used the letter of protection, and the past medicals were $81,000. In South Florida, I expect the value of a case to be a multiple of 4 times past medicals. Up here in North Florida, I expect it to be about 3 times past medicals. So I expect the value of this case in a clear liability fact pattern to be approximately $324,000 in Miami. But it gets even weirder. The doctor, these letters of protection are notes receivable. They're an IOU. They have some value. They always sell the letter of protection immediately to a factoring company. All these factoring companies, according to my research, are owned by other plaintiffs' attorneys, because this is another lucrative line of work. They buy the notes receivable. In this case, they bought it for $18,300. The jury is being told this is the past medical number. The jury has no idea that this person could have been treated for $7,000. And this is what was producing these big verdicts. This is what was producing big settlements at mediation. And so the law now is going to be, you're going to, it's sort of bifurcated in terms of past paid and past unpaid. Other numbers the jury can look at. If you have insurance, what would that number have been? If you don't have insurance, what is being charged in the relevant geographic area? And a number that could come in to dispose of that would be 120% of Medicare or 170% of Medicaid. Likewise, this happens in the medical community. What is the value of medical care? The language they speak among each other are code sets, like CPT codes. These LOPs never had code sets, okay? That would be kind of like going shopping at Publix and someone telling you this bottle of ketchup is $300. And you say, well, wait a second, ketchup is usually about $2.50. How did you get this big number? And you want to compare that, but they say there's no codes or no scans to compare that, even though in every other setting for healthcare, except for personal injury litigation, they use those code sets. And then from there, the next important part of this legislation is that crazy referral I described, where the injured person is referred to the treating plaintiff, the treating doctor. That was always protected under attorney-client privilege. Everybody knew that treating doctor had got to that plaintiff because of a referral from the plaintiff's attorney, except for the jury. They didn't know that. Now they're going to know that, and when they see that there's a big number for a past medical, and then they're also going to see that they sold it, they might think to themselves, did this person really need this treatment? Did it really cost this? They'll be able to sort of weigh the potential bias of a treating physician. So this is critical and a big part of what we call transparency and damages. Now, to make this work, we had lots of different examples. Here is an example, and a big part of this too. Those green examples were past unpaid. A letter of protection was a past unpaid, but the jury is now going to actually see the paid amount too. And you've probably all experienced this as well. You go to the doctor, you see a huge charge, but what's actually paid, okay, is this pink number, this small number. Plaintiffs' attorneys had a tendency to identify who had the biggest charges in a relevant geographic area, send those people there. The juries were hearing a big charged amount, having no idea that there was a small paid amount. And the problem is our jury system works when jurors have a relative understanding of something. They understand the concept of a green, yellow, red light. They know what a loaf of bread costs, but they've never heard of a percutaneous discectomy. They don't know what it costs. So if someone wants to say it costs this, okay, or someone wants to say it costs this, there's a tendency for the jury to believe it, especially when there's a clear liability fact pattern. And I'm the tort reform guy, and a lot of these cases are clear liability. It's really a function of damages. So that's the transparency and damages issue. And this here I've developed for you all and people, and I gave this to legislators. This is a sample verdict form, and you can see that the bigger the pass number tends to be, and that's the pass number there, it sort of sets up and makes the other numbers bigger, and the overall verdict tends to be bigger. And that's why it's so important, in my opinion, that jurors hear the real number of past medicals. And from now on, that is going to happen. And also overturned the Worley case. Next substantive issue, Ashley's going to take.
Yeah, and William's right. Transparency and damages is probably the biggest thing, just from a everyone feeling it standpoint, that you'll see in this legislation. The whole concept of tort laws, if you hurt someone, then you kind of get them back to where they were before, right? That's the goal. Just like what I talked about the plumber scenario, the goal is to fix whatever problem they have. But if you're actually just paying what it costs to get them whole, how does the plaintiff's attorney get enriched? They can't get enriched if all you're paying is what needs to be paid to get that person whole again. And so this whole kind of complicated scheme was created, and through a series of court decisions, including the Worley decision, kind of reaffirmed, and it created this whole kind of complicated scenario by which you could inflate damages past what they were in reality to be able to enrich the attorney and also enrich the person. I mean, when you drive down the highway and you see someone who appears to have no permanent physical injuries holding a sign that says so-and-so attorney got me $4 million, you're like, but you look fine. Like, what costs $4 million? Like, I mean, I don't understand, but that's literally how all of that was happening, because if you just fixed his broken leg, that would not have been $4 million, but if you could have convinced someone to go to a crackerjack doctor to do a bunch of unnecessary procedures, which was happening sometimes, and also inflate the bill, then all of a sudden the guy who looks perfectly fine with no lasting permanent injuries, they can get $4 million. And that's how that was happening. Negligent security was one of the ways that you could kind of get into the courthouse for a liability case, and then of course apply the whole transparency and damages fact pattern and inflate damages. But negligent security is a form of premises liability, and so places like this have a duty to kind of keep their premises free of hazards and relatively safe, so that we don't slip and fall. And everyone here appears to be doing a great job at that. A lot of businesses do a fantastic job at that. They want their customers to be safe. They want their customers to come back. Negligent security is a form of premises liability that basically says you have a duty to provide adequate security to patrons and invitees. And that's fine, right? That makes sense to all of us. Like, okay, yeah, you should probably do what's like customary in that, neighborhood or location to kind of keep people safe, maybe locking the door, whatever that looks like. But what was really happening is that several very smart plaintiffs' attorneys had convinced the courts that through case law to make a standard that we don't think it was quite right. And the standard was basically this: anything that's ever happened in a 3-mile radius within the last 3 years, you have a duty to anticipate and you have a duty to prevent. Okay? So where are we located in Tallahassee right now? Right. There's lots of muggings, sadly. It's not the safest neighborhood. So if someone walked in here and did what they do maybe a mile away, this place has a duty to not only anticipate it, but to prevent it. And so you had businesses who were saying, well, there's no way I can adhere to that standard short of having an armed militia outside of my door. I have a downtown office. We have a homelessness problem in some parts of downtown. We can't hire 24-hour security. I mean, I guess we could, but that's a big expense. You see it a lot of times at apartment complexes. People invite a guest over, and an apartment complex really is not supposed to be the hall monitor of who people get to have over for dinner, right? But If someone gets hurt, someone gets beat up, someone gets shot, sadly, they sue the apartment complex and say, hey, there was a shooting 2 miles away a year and a half ago, and you should have prevented this shooting from happening. And they're like, the apartment complex is going, what? Like, this person got in a fight with their friend who they had invited over. Like, how was I supposed to know that this was going to happen? They said, you had a duty to prevent it. And you didn't prevent it, and therefore we're going to sue you for negligent security, which is a subset of premises liability. And so people like William and I were like, this is a wacky standard, right? Like, this is totally insane that basically you have to prevent everything. And what was happening, particularly I represent the Coalition of Affordable Housing Providers, which is a statewide coalition of people that build affordable housing. And they were like, this is insane because I am being sued for things that I could never in my wildest dreams have prevented. Even if I know that sometimes these things could happen, but I can't charge $750 in rent if I have to have 4 armed guards 24 hours a day. Rent just became $2,500 a month. I can't do that to people. My residents can't tolerate that type of price increase. And so we looked at other states and we said, well, how do we make this more fair? And what was happening is, because negligent security is a negligence act, they would sue, I'm going to pretend that you're a Joe Q property owner, and say you were negligent in not preventing this person from doing something to me. I'm going to sue you in negligence, and you're 100% responsible for the damages that happened to me. And you're going, but this guy mugged you. Like, how that wasn't my fault. I mean, I'm sorry, but I had all of the appropriate lighting. I even maybe had a gate. I had, people walking in and out, and I'm really sorry this happened to you, but I did not do this. You couldn't tell a jury to consider that person's fault for my damages at all. They say, nope, it's a negligence action. That was an intentional act, so it's different in kind. I'm only suing you for negligence. You couldn't compare the fault of all people who kind of contributed to something. And so in House Bill 837, it says, no, you actually can look at the fault of all people, even if they acted different in kind. One is negligence, one was an intentional act. You can consider the fault of all people and how that combined to cause damages to a person that was on your property. We had a number of local businesses testify in support of the bill generally, but Roy Moore, who owns some of the Piggly Wigglies here in town, he actually testified in support of this issue too, and a number of others. And he talked about food deserts and how do you run a grocery store in an area that does have a higher crime rate if you're constantly being sued and 100% liable for things that you had no ability to prevent in your parking lot. Even if you have the best lighting in the world, right? Which they do at that complex. And so it became a very real thing. Not necessarily on this issue, but we had Tasty Pastry, the owners of Overrun Under Bar, a guy who ran some of the IGA stores here, and A&E Wholesale. They all testified in support. So it's always great to have grassroots people kind of come in and say, this is how this is affecting my business. One other thing that we did in House Bill 837 is for multifamily residential complexes, where it basically said, hey, if you kind of comply with what we think are best practice safety standards, you're going to get what's called a rebuttable presumption against fault for negligent security. So basically it works like this. I sue Becky, who owns my apartment complex, and say, hey, someone mugged me in your parking lot. Becky's like, I'm really sorry that happened to you, but I actually had all of the locks, all of the lights, all of the gates, all of the key fobs that I was supposed to have, and I got this cool thing called a CPTED assessment, which is called Crime Prevention Through Environmental Design. A lot of law enforcement agencies offer it. And they came into my property and they said, hey, Becky, based on where your hedges are, based on your kind of environmental controls, here's what you need to do to kind of create a maximum deterrence environment. And we kind of felt like that was the right standard. You can't prevent everything, but are you negligent for not preventing everything? I don't think that's true. And so you're negligent if you don't kind of create a maximum deterrence environment, seemed to be the place. And so we had to define, how do we get to a maximum deterrence environment for multifamily residential buildings? And so that's in there. Basically, there's kind of a number of core things that they have to do, but then they also have to get a crime prevention through environmental design assessment and fully comply with it. And then they get to kind of rebut someone's insinuation that they were negligent for premises liability for failure to provide adequate security.
So these are some of the folks that testified on that. Modified comparative negligence, that is another issue. These are the yes folks and no folks. And what I'm about to describe is how a verdict form works. prior to this law in Florida, we had something called pure comparative fault. And what that meant is that you, in often cases, you're judging not just what the fault of one defendant is, it could be multiple defendants, but you're also looking at the actions of the plaintiff. So if there's a multi-defendant case, maybe defendant 1 is found to be 20% at fault and defendant 2 is found to be 80% at fault. So defendant 2 in that example pays $800,000, okay? Another kind of way to look at this is sometimes the plaintiff has a percentage of fault. Sometimes their percentage of fault is greater than 50%. We heard a lot from the trucking industry on this particular issue as well, and a lot from retailers, etc., and grocery store owners, where a truck, 18-wheeler is going down the road, okay? They're going 65 miles per hour. They're in the left-hand lane. They turn to the right-hand lane, but they don't turn on their blinker. It's called a tort if something bad happens. One of the reasons they didn't do that is because they looked in their rearview mirror and the motorcyclist that was behind them, they assumed was going 70 miles per hour. Unbeknownst to them, that motorcyclist was going 100 miles per hour, okay? So when they veered into the right lane, sadly, tragically, the tractor trailer hit the motorcyclist. Jury hears everything. A jury might in that fact pattern say, trucking company, you're 20% at fault, but motorcyclists, you're 80% at fault. And maybe if the verdict was $2 million, trucking company pays $2 million. Now the trucking company is saying, now wait a second, this really happened because this person was going 100 miles per hour. At some point, if you get to 50% or more, the fault maybe lies with the plaintiff who's actually bringing the lawsuit. So here's an example of a real case, and we collected real cases like this. This is a lady who came to shop at a grocery store. There was a something called the stock float in front of her. She got there first thing in the morning, in front of the produce aisle. She moved the stock float, got the produce out, forgot she had moved the stock float, and all of this is on a video camera, turns around and flips over the stock float that she herself had moved. The video is shown to a jury, trial, depositions, etc., everything comes in. Jury says, you know, we think you're 60% at fault and the store owner is 40% at fault. Well, then you look over here, you see how the math works, okay? On a total verdict of $182,000, the defendant still pays, okay, 40% of that, okay? And there's example after example of this. And what the Florida legislature said, you know, wait a second. If you're 50% plus 1 at fault, this is your fault and you can't recover in these fact patterns. So that's the modified comparative fault example. Here's one. Plaintiff is found to be 83% at fault, defendant 17% at fault, okay? 70%, 30%, so 75-25. So that happens, okay? What we have just described for you is House Bill 837, done by Representatives Tommy Gregory and Representative Fabrizio, and Senator Hudson, signed by Governor DeSantis, with incredible work on the part of our Senate President, Pasadomo, and our current Speaker, Paul Renner. This could not have been done without their leadership. We played a role in helping advocate on these issues, and hopefully they make sense to you. The trial bar has demonized this legislation, okay, during the whole process,
I'm
since
sure everyone's
its process.
commercials.
But me and Ashley, we've been
February, March.
speaking to business groups the whole summer, and every time we do, everyone says, look, those just sound like common sense reforms, and that's what we think they are. You know, Doug asked earlier, is Florida a judicial hellhole? No, I do not think so as of 2019, okay? The court changed, and I think we have the best court system in the country now since 2019. But if you're a circuit court judge, you're a trial judge, okay, we have the Second Circuit here, and a fact pattern comes to you, you can't overrule existing Florida Supreme Court precedent. Only the Florida Supreme Court can, okay? So these are all areas of law that the legislature had to address and get involved in. Now, that was House Bill 837. There were several other smaller bills that passed this year. One dealt with construction defects by Representative Snyder and Senator Hudson. What was happening here, there's something called a statute of limitations. I described that to you. That's the amount of time you have to bring a lawsuit. There's a related but different concept called a statute of repose, where you can't bring a lawsuit after a certain period of time. So in a construction defect case, if you knew something was wrong, you have 4 years to bring it, okay? Some people might not find out something's wrong until year 8, okay? But that doesn't mean you had 12 years. There was a statute of repose where you couldn't cross that wall. In Florida, it was 10 years. It's now been reduced to 7 years, okay? Because a lot of these construction defect claims, plaintiffs' attorneys knew when the homes or condos were built. They'd send out teams to knock on the door for construction defect claims right around the statute of repose time frame, 9.5 years to sign up people for particular claims. And in condos and apartment complexes, that triggering period of time was when the last unit was built. And so some of these might have 250 units. The lawsuit may be being brought really by the owner of unit 1, but unit 250 was built 5 years later after unit 1. That sort of was adding an additional 5 years under the statute of repose. So some of these lawsuits were being brought 12, 13, 14 years, 15 years after the fact. And you remember that example I gave you of the hapless restaurant owners. Well, the construction community, they have to then go figure out who were the subs and the subcontractors on things, and it was just too difficult to defend these cases, and it was like shooting fish in the barrel. So the statute of repose has been reduced to a more manageable number, which is 7 years, okay? Telephone solicitation, Ashley's gonna talk about.
Telephone solicitation, I don't know if you like this bill? Oh, okay. There's a federal law called the Telephone Solicitation Act, which kind of prevents like robocalls, which we all think is a good idea. So anyone who uses what's called an auto dialer, which is kind of a thing that usually someone who's overseas just kind of tries numbers, right? They churn till they get one, and that's why it takes 30 seconds for them to mispronounce your name and try to sell you something, right? That's called an auto dialer. Florida has a similar act on its books. In the state, it's called the Florida Telephone Solicitation Act. And we added a private right of action a couple years ago, which basically meant you could sue if someone robocalled you. Well, one of the cute things about robocallers is they usually don't tell you where they're from, right? So I'm calling you from China. Like, great, even if you told me you were calling me from China, I don't know where to find you, nor could I even try to spell your name to try to track you down in Beijing. Couldn't happen. But regular people who use calling to solicit people, they tell you. Publix wants to give you a coupon for a chicken tender sub. Your hair salon wants to give you 15% if you book on a Monday. Examples like that from businesses large and small. What happened is when Florida said that they were going to allow a private right of action, so someone to sue if they've been called by a robocaller, is they didn't define what an auto dialer was. They didn't use the definition under federal law of an auto dialer, which is what I described to you, which is go, 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 go till you hit it. They used a definition that actually captures this. So we had cases where someone had booked an appointment at a car mechanic, and it was coming up to their service, and the car mechanic reminded them about their service or asked them if they wanted a certain feature added to their service, and they would actually get sued for reaching out to their customer. We had a financial advisor who had a business relationship with a customer and just reached out to kind of say hi. That was considered a solicitation, because guess what he used to reach out? An auto dialer that was undefined. Under this law in Florida, you would get $500 of damages for every call or text that was unwanted and unsolicited. And they considered unsolicited to be anything where you didn't have express written consent. So you didn't sign something to say, yeah, this person can call me. What they would then do is they had professional plaintiffs. So actually the only people bringing these cases were like 4 plaintiffs' attorneys and their immediate family and friends. So they would actually have their friends often get multiple phone numbers. And oftentimes they'd get those mint numbers or the ones, because when you surrender a number, it's usually reassigned within 30 days. So you'd have them going to like Walgreens and buying a bunch of phones, collecting all of the messages that the previous owner of the phone used to receive. They'd say, I didn't give you express written consent for that message. I am suing you. My brother-in-law is going to bring the lawsuit. It's going to be awesome. You're going to not only owe me $500, but I'm going to sue you under the FTSA, and I'm going to try to get a class action. And the class action is really cool because I can actually get discovery against you for every single person that you have ever sent this text message to. I'm going to try to certify a class, and then all of a sudden $500 for every person that has ever sent that text message becomes several $1 million. If you're a hair salon and you've sent it to 300 people, think about 500 times 300. That's a lot of text messages, but they were from your customers. They had opted in. They had said, click to subscribe. I get children's clothes all the time. I mean, I can't imagine how many people they send children's clothing, solicitation emails to. There were very reputable companies that have never robocalled anyone, including people like Publix, who were sending coupons that were getting sued for potential millions and millions and millions of dollars. And so we came in and said, that has to change. We have to crack down on what a solicitation means, right? A solicitation doesn't necessarily mean you had a wet signature from someone to be able to contact them. Solicitation means they took an affirmative step to opt into something. And so we basically changed a law to say that, and we made it applicable to some of these kind of pending class actions to say if you hadn't yet certified a class action that they could kind of get out, because some of these companies who were smaller companies were facing complete financial ruin for sending out coupons to customers who had asked for them.
We're running out of time here, so.
Yeah, this is another shade of the one-way attorney fee issue. They were doing it in auto glass. You had a couple of attorneys that were doing all of it. In the first quarter of 2023, 10 lawyers did 11,000 of these auto glass lawsuits. One of them did 1,700, one of them did 1,400. And so this is kind of a reform that cracked down on just ridiculous scale of litigation over small dollar amounts.
And there was another bill dealing with truth in legal advertising. Some of the ads you see on TV are not done by attorneys, so no one can regulate them. They tend to be the more incendiary ads that the Florida bar never would have allowed a Florida attorney to approve. You might see names like Nightline Legal, that's actually a appeal box in California. They then collect plaintiffs' names and then they refer those cases out for a fee. Now there's going to be regulation on the part of the state of Florida for non-lawyer advertising. So, Doug, that's kind of what we did this year. And
That's a lot.
if you,
I don't know, I'm gonna ask, if you have a question, put your hand up, maybe Catherine can come around. Oh, we have a few questions. All right, we'll go ahead and start, let the floor take over. Go ahead.
Okay, thanks, Doug, and thank you for the overview. Obviously, this is a watershed moment. Two questions. One's the quick one. When does this all go into effect? Is this July 1st, or we're looking out over a period of time?
it went into effect the day the governor signed it, March 24th.
Excellent, okay. Second question is, over the 20 years of trying to do this tort reform, it always seemed like it was the Senate and trial lawyers in the Senate that held this up. What changed this time around? How much of it was the governor versus maybe more conservative senators? I'd be interested in knowing.
I think it was the leadership of Governor DeSantis. Without him, this wouldn't have happened. And we had two extraordinary partners in the Senate, and President Pasadomo and Speaker Renner, and just two sharp sponsors in Representative Gregory and Senator Hudson. So in some sense, the stars aligned, okay, and we got 3 green lights. Sometimes we've had 2 green lights, 1 red, 1 green, 2 yellows. Things did align, and there's a method to the madness of pushing these issues every year, even if you're not going to be successful, because what you're doing is you're building a foundation. Okay, someone like Paul Renner is a freshman when he first hears these issues and later becomes the speaker. Okay, someone like Kathleen Pasadomo is a freshman House member. She's in the House for 8 years, then the Senate, and becomes Senate president. She's familiar with them. So building that foundation over time, each and every time these issues were talked about in House Civil Justice, House Judiciary, Senate Judiciary Committees, I thought it was an embarrassment to the state of Florida. I thought it was embarrassing that anybody could come and defend these type of lawsuits, but that's what the plaintiffs' attorneys were doing year after year after year after year, much to our frustration and a lot of the folks in the business community. Lucky for us, stars aligned. Governor DeSantis got this done. So,
do one more question.
The number of suits that were filed a couple of days before the governor signed your first bill kind of puts what the impact of that will be. In that bill, if you had to choose one element, what is most important? I'd kind of go the modified comparative, but you're closer to it.
I think the transparency and damages, then the third-party bad faith, then maybe the one-way fees, and then the modified comparative fault. I mean, they were all in themselves like a Super Bowl issue, and we've got 8 Super Bowl issues, you know, across the line. So it's extraordinarily, each one of these issues are, you know, very important.
So one final thought, is there one thing we need still to do? Is there one big issue out there that still needs to be addressed that affects us?
Yeah, there's some issues out there on asbestos litigation, medical malpractice litigation. There's still a lot to be done. A lot of these issues, you know, existed because of prior case law, and maybe a case is going to get up to the Florida Supreme Court on these issues, but maybe not. I think it's very important that public policy individuals who are rightly in the legislature, you know, need to address these issues, and hopefully a few of other ones are going to get passed in the near future.
That's great. Y'all join me in thanking William and Ashley for a very informative presentation today. Appreciate y'all coming.